The next category of interpretive canons relates to the structure or context of statutes. But like the other canons we've considered, they can apply to other types of texts, including constitutions, promulgated rules, and legal documents such as contracts and wills. The whole act canon requires consideration of a statute's entire text, structure, and the relationship between its parts. This is one of the oldest and strongest canons. Coke explained it early in the 17th century, and the United States Supreme Court has followed this canon since its earliest days. The canon requires that courts look not just at particular statutory language, but also at the whole design of the statute and its object and policy. Statutory language must be interpreted not in isolation, but instead as part of the whole act. Especially in complex statutes, the entire document provides context for each part. This canon presumes that, absent convincing evidence otherwise, a given term means the same thing throughout a statute. Moreover, a material variation in terms suggests a variation in meaning. This arises from the natural presumption that identical words are intended to have the same meaning when used in different parts of the same act. The Latin phrase, in pari materia, literally means in the same matter. This canon provides that different statutory provisions concerning the same subject matter must be interpreted consistently, whether in the same or different statutes. If a statutory provision is ambiguous or unclear, a court should look to the remainder of the statute or other statutes in the broader statutory scheme to determine the meaning of the ambiguous language. The canon applies most forcefully to statutes enacted by the same legislature within the same legislative session.